Good day, listeners, and welcome to Beyond the Checkbox, where you learn how to integrate more mental wellness into your organization through frontline leaders. I'm your host, Ryan Todd, and we are joined by two esteemed guests today, Kent Jesse and Ben Kormos, who are both lawyers and have expertise in employment law and labor relations and agreements, and we have them on due to popular demand and being inundated with questions around what do I do with my employees in the time of COVID? So thank you two gentlemen for joining us today.
Thank you.
And I want to get right into it because we have so much ground to cover today. We at Beyond the Checkbox have had so many HR leaders and CEOs, leaders, tons of conversation on social media about the legalities around all this because it's in such new territory. Everyone's working from home now by and large. And I find in times like this, people turn to the law to say, what do I need to do? Not what do I have to do, but what are the legalities around what's going on? So Ben, I might just start with you. What role are lawyers playing in all this? What are you seeing on the front lines? How is this impacting your practice?
Well, it's a good question, Ryan. I think right now lawyers play a very vital role in society in terms of guiding people and being almost that hiking guide through a very difficult terrain right now. It's very unfamiliar territory. And to quote the Chief Justice of Canada, she said that Canadians can be assured that the justice system continues to function on their behalf and the rule of law prevails. And so we're really the frontline workers when it comes to guiding people through this. Right now, there's reference on the court websites to canceled court meetings. The adjudication process is a little bit slow right now. And so people are really reaching out to lawyers to get some guidance and say, what is it we're supposed to do? What are employers' obligations right now? So we're really guides.
And is there, like in medicine, hospitals are triaging because the demands on the hospital system are intense right now. Is there a similar triage system? Like you said there was some cases being canceled or delayed. What cases are rising to the top? Like what is of utmost importance right now?
That's a really good question, Ryan. Right now, the criminal cases and things that are very urgent are what the chief justices of all the provinces have decided rise to the top in terms of triage. People who are in custody and awaiting hearing, and as well domestic issues where there might be some family violence or issues that need to be dealt with inside the home. Those and child custody matters, those of course rise to the top. Civil matters where things like folks who are claiming money or claiming invoices, those types of claims don't really make that cut right now. And so lawyers operate in that space right now in terms of working out their clients' difficulties and guiding people through this process in this difficult time.
And are people just straight up reaching out to you? I mean, there's the whole court process and litigation and adjudication, but I imagine there's another role for lawyers, for clients just reaching out to your firms and you personally just looking for help and assistance.
Yeah, and that's one of the roles that we are playing. I'm noticing that we're getting more calls in terms of what to do, and even when it comes to things like what are my benefits supposed to do in this situation? What are my obligations as an employer to accommodate people? So yeah, we're getting more of those.
When things go awry like this, where do you I see all you have those beautiful textbooks behind you, and I hope that's the law. That's what I think the law is back there, but it may not be. Where do you as lawyers turn to get the foundation or the backstop of what you should be following or what precedent you should be using.
Well, and that's just it. I think in terms of our professions, there's a cumulative knowledge you get with more experience and expertise, and there's a certain mentorship you get when you work in a firm like ours. We've got an over 60 year history in Calgary. We've weathered a number of challenges, and I think people look to us as experienced practitioners who have that kind of mentorship and collective knowledge over our careers to really know a cumulative sampling of experiences that we can guide people with.
So it's a team thing too. It's a team approach in your reasoning through things.
Absolutely.
And Kent, what are you seeing on the front lines? What's your experience been with COVID and all the employer relations? How has this been impacting your practice?
Well, as Ben commented, most of the court hearings have now been canceled. The test is basically one of it has to be an emergency to proceed, and before you're allowed to have access to the Court of Queen's Bench at this moment on an emergency basis, you actually get vetted through one of the court clerks, who is her full-time job right now is to consider those requests. Those that meet certain criteria get passed on to the judge. And the first thing the judge will ask you when you will get in front of them will be, what is the nature of the emergency? As Ben commented, there are things like domestic relations and whatnot that tend to be considered more important at times like this. If you merely have a monetary claim and you say someone owes you money, that is not a claim that is going to be heard in the next little while.
It strikes me that this could change a lot of things. Like we're seeing a change, a dramatic change in workplace culture. We're seeing a dramatic change which in the way we interact, in the way our kids are allowed to interact. And I'm wondering, using your crystal ball, how will this impact the law, these changes with COVID and our, self-isolation, social isolation? Do you see this impacting how we legalize or do the law or practice law?
That's a good question. And getting ready for today, and most of our research tools now are already online, but I did a quick search to see if I could find any cases that even talked about, for example, how does the law apply in terms of contracts in the case of a pandemic? And of course, Canada hasn't, to my knowledge, seen a pandemic before. And so lo and behold, there was no case law. So in that regard, that's the bigger question is, how will the law respond to a time like this where there's appears to be a pending crisis, if it's not a crisis already, in terms of alleviating obligations or enforcing obligations that people have to one another, not infecting each other, those sorts of things. And right now, people are being asked to, in some cases, self-quarantine or quarantining themselves. You're seeing, in my case now, I'm even working from home, which is much more possible now than it ever has been. But you're going to see, I think, digital access become critically important, especially in terms of administering the law. Perhaps this will prompt the Court of Queen's Bench to move quicker towards electronic filings, for example, as opposed to paper filings, because right now we still do our paper filings. We send the paper filings down. That means a person has to handle them. It would be much more efficient and frankly safer from a germ perspective, I would think, to not have a whole bunch of people's hands on a bunch of paper if you can do it digitally. That's one example.
So I'm hearing that, like, from a legal perspective, this hasn't really happened before.
I've never heard of a pandemic. I mean, I remember the SARS and I remember swine flu, but in Canada, at least, it didn't seem to impact us to the way that this is, or to the magnitude, and that this is about to.
And so my question around that is how, so if this has never happened before, how does the legal system maintain the rule of law? Like how if there's nothing to precede this, how do you make sure the rules are being followed if there's no rules? Take me through that process a little bit.
If it's an emergency, it will be heard. If there's a threat of immediate violence to you, if there's the need to preserve property urgently, you're going to be able to get in front of a judge in a short period of time, just like you always have been able to. If, on the other hand, you have lingering disputes in respect of, who knows, it could be a tort, somebody hurt me, it could be a contractual claim, somebody owes me money, It could be a type of negligence claim. It could be a car accident. Those kinds of things just don't rise to the top or become our priorities at this point in time. Right now, while we're in effectively a legal triage situation, it's truly only emergencies that are being heard.
The contractual piece, that's not as urgent right now in the eyes of the legal system. Do you foresee? I guess it depends what kind of contract we're talking about.
Yeah, I mean, if you have a contract where, let's say, there's like, trying to think of an example. None has come up in my practice in the last week or so, but if you need to preserve something, like, let's say, for example, uh, property is about to leave the country and it shouldn't be, you could, for example, conceivably go in and quickly get a restraining order to say that property stays here, and we'll resolve the dispute once the crisis is over. That would be one example of, for example, a contract issue where it could become urgent and could be heard right away.
So there may or may not be a backlog of like these employer and labor relations type of agreements and contracts.
Well, I think those in particular it would be hard to imagine. I can't think of an instance right now where an employment claim for example, wrongful dismissal or uh, temporary wages would be heard or would be considered as an emergency. Right now, what you're seeing, and the announcements came through last week, both from the federal and the provincial governments. They're instituting wage supports. They're instituting certain measures to help businesses cope with the loss of revenues in many cases. So it's more, you're seeing more, it's the government programs that are responding. Employers themselves are very much being harmed, if you will, or feeling the effects of this every bit as much as the individual employees that they have that help them run their businesses. So it's not, while the employees, especially if you've already been told you can't come to work anymore, that's probably causing you a lot of harm right now. But there's no legal mechanism to go and say, well, I can't work, therefore you should still pay me. That's not the law. The law is all about an exchange in terms of work. So if you, in relation to employment, so if you provide services or to your employer in exchange for a wage. If you can't do that, or if you don't do that, there is no obligation for the employer to pay you in most cases. There could be some exceptions to that. However, there have been put government programs in place. Even just last week, the government of Alberta announced some wage support type programs. The federal government has given incentives for some businesses to stay open, which is interesting in and of itself, in that it appears they're encouraging the businesses to not shut down by, for example, offering a 10% subsidy for all employee wages paid during a certain period of time, a 3-month period I think they just announced that yesterday.
There's a lot there, and I want to just get into some of the weeds here. There's a lot of small businesses across North America who have had to lay off like 80% of their workforce. I think by and large it's seen as a temporary move until COVID, blows over, and then they can get their employees back. So I see some confusion with like their employment status. Like they're kind of fired and they're on EI, but they're kind of being taken care of still by the company with the expectation of them coming back. What are the hot spots there? What do you foresee in terms of issues that can arise from these like temporary layoff situations?
So first, maybe the basics of what the layoff situation in Alberta is, and as far as the law is concerned. And this does not apply to those people who are subject to collective bargaining agreements. First, you always want to go to if you have a CBA, a collective bargaining agreement, that will typically govern what the rules are for layoffs. If you do not have a collective bargaining agreement, then this would probably apply to you, and that is there are layoff provisions in the Employment Standards Code, and in Alberta, and they're different province to province in general, but in Alberta, the employer has the right, with providing 1 week notice, to lay an employee off for up to 60 days during any 120-day period.
Can you take me through that again? Because I think that's a lot of our listeners will be tuning into exactly those details. So just tell me that again.
So the employer has the right to lay off an employee, and typically for lack of work, or the mutual inability potentially to perform the services that the business does, for a period of 60 days and no more than 60 days during a 120-day period. That effectively pauses the employment contract. So the employee doesn't have to perform any services. It also alleviates the employer from the obligation of paying wages.
That's for a 120-day period. If we foresee this going beyond that, is there a precedent to figure out a situation there? Like, let's say this is a 6-month thing.
Interesting question, and it's because it's going to, it's potentially going to be a massive issue, and there is no legislated response to that, at least not yet. The general rule has always been, as long as the Employment Standards Code has had those layoff provisions, is that if you go past the 60 days, your employment is deemed terminated.
Okay.
Now, conceivably, and I was thinking about this issue actually just yesterday for an employer who believes they'll be gone longer than 60 days, but he says, well, what if my employees mutually understand that I can't operate and they don't want their employment to be terminated after 60 days? Can we agree to say, well, notwithstanding that the Employment Standards Code says 60 days, my employment won't be terminated after the 60 days? And the Employment Standards Code is very clear that it represents the minimums to protect an employee in general. So insofar as one would say that the 60-day layoff protects the employee from having their employment terminated, and the employer mutually also doesn't want the employee to be terminated because of the nature of this pandemic, and the intention is to resume business as normal as soon as reasonably possible, could the employer and employee agree to waive that 60-day deemed termination? There's no definitive answer to that. I would, my own view would be, well, why not? If both parties want it, I mean, in any event, but that being said, the way the Employment Standards Code itself operates is it says that there's basically a deemed termination after 60 days.
Interesting. And the Employment Standards Code is, are we talking, is that a provincial code? Is that a national? Okay. And would it change drastically from province to province or even state to state?
I can't say that I'm familiar with the layoff provisions in other provinces. I understand that they're likely similar. I do believe Alberta might be unique in the 60-day period. And to give you an example of how that would work, and this literally just came up last week, where an employer was having us vet a layoff notice letter, and it contemplated about 90 days of layoff. And of course, the employer didn't know what the layoff provisions were. And so we said, if you send out a layoff notice for 90 days, you've technically terminated all of your employees because the law only allows for 60 days. So I think at this point in time, the most important thing would be for employers and employees to talk about these things and figure out what they think can work best for them in their circumstances. Some businesses, of course, will continue to run and operate. There's some essential services that would be probably almost impossible to shut down. But for those that you've used the 80, some have laid off 80% of their workforce, there needs to be a lot of communication there, because unless there's an orderly way to return to work and a way to resume the business, some of these businesses won't survive, which means some of these jobs won't remain when the crisis ends.
You bring up a couple of very interesting points about, you said there needs to be a lot of communication. My sense of it and talking to small business owners is that when they're unfortunately having to lay off employees because their business has been shut down by this isolation policy. A lot of the employees get it. There's no hard feelings. It's not contentious. But that's not across the board. There might be other cases there. I'm wondering if there's a thing here where you can over communicate without knowing things. And I'm wondering, Ben, from your perspective, are there situations that you're finding where you can over communicate, not under communicate, and you don't really know what you're talking about and you can get yourself in some hot water? I think there's a lot of business owners who are worried about that particular issue, talking about an issue where they don't have expertise in. Can you speak to that?
Yeah, thanks, Ryan. Absolutely. I think in this situation, by definition, we're in unprecedented territory. And so what that means from a legal perspective and a common sense perspective is that nobody knows the answer in terms of exactly what the obligations will turn out to be, because we work in a common law system. And so although there's legislation that Kent has discussed, there's also a layer of authority that the courts and lawyers use to sort of determine what's reasonable in Canadian society. And so I think it was one of the justices of the Supreme Court of Canada came and talked to our law school at one point, and he made a lawyer joke by saying, what's the answer to X, Y, or Z? And he said, well, it all depends what's reasonable in the circumstances. And of course, that got some chuckles from the lawyers in the room. But I think the definition of Canadian
such a wild sense of humor, you lawyers.
we're a real treat at cocktail parties. But I think that Canadians want to act reasonably, and so there's some truth to that comment. And so employers, I think, are in this situation where they're trying to be reasonable. They're trying to be fair, and I think that's a typical Canadian trait. And Albertans, I believe, are no different. So there are some risks, as you asked, in terms of what does an employer do? I think the fairest answer in this situation is to reach out to counsel and say, listen, I don't know what to do. Can you guys guide us? And meanwhile, the message to the employees can be just almost a feedback gathering mechanism of saying, I'm here, I'm your leader, and I'm listening. We're all concerned. Be honest, we're all concerned about what's going on right now, but we're in uncharted territory. Let me get back to you, because there might be this temptation to have the answers as an employer, but when you don't, I think the fairest answer is to say, I don't yet know, but I'm going to get back to you real soon. And meanwhile, take that opportunity to reach out to qualified counsel to find out what are some of the ways that they can deal with this, whether it's coming up with contractual solutions, doing some research, because everything's highly specific in terms of what type of organization the employer is running, what type of workforce that they have, what's the mix of people. And so I think that's crucial when we're dealing with an era where the soft approach is very important, as I think it always should have been. We're talking about employee wellness and their livelihoods.
I want to talk about that, the wellness piece, in particular around benefits. Have you seen any sticky spots with either layoffs or temporary layoffs, and or sick time? What are the hot spots in the world of benefits right now?
Well, and I think it's too early to be honest with that question. We're going to need some more examples coming through. But what I can say is I've been consulted on a couple of cases where employers have stayed open and almost fully operational in a fairly complex and fairly populated space. And without getting too specific, they're an employer that has the public coming and going all the time. And so when you have staff that are saying, well, is one of my benefits in this scenario the ability to have really flexible work hours, where if I'm concerned and I've got family at home and I don't want to be exposed to that work environment, what can I do as the employee? And so to guide the employer through that, we would need to look at things like their policies and procedure manual. We need to look at past cases of their HR department. What have they done for other employees before the pandemic to offer flexible options for working? Because some of those things have a practical effect, even if they're not directly legally relevant to the next employee who comes along. Employees talk. And so, of course, they're going to know at some level what their fellows have received in the past. And so I think there's a lot of practical elements to the question, but I think being really fair, being understanding, but not exposing the employer to undue obligations, that's the balance that's being struck right now, Ryan.
And Kent, I want to get your take on this too, because I know it affects kind of both of your practices. Do you, like, there seems to be opportunities for a lot of goodwill here. There also seems to be opportunities for exploitation. Have you, quite bluntly, have you seen any of that exploitation or cases where obviously an employer or an employee is taking advantage of the situation?
I have not seen, I've certainly not seen any what I'd call intentional exploitation. Certainly get calls from an employer asking, what should I do? I have my employees who are worried about coming into the office or into the workplace. If I allow them not to come in, and that means I might not be able to perform my services to those who want it in turn. And so I would say it's been more of an issue of concern as opposed to exploitation. And as Ben said, this is uncharted territory. So people are going to learn as we go along. But I can happily say that I am not aware of a single instance of what I would call exploitation, or not, and that's from the employer side. From the employee side, I'm not aware of any situation of an employee, unreasonably taking advantage of an employer's goodwill to say, in these circumstances, we think it's okay if you stay home. For the most part, in fact, universally, I've found that both from the employer and employee side, people have been willing to work things out and make reasoned decisions.
Is there, what legal grounding is there for an employee who says, I don't want to come in? Is there legal backing to support that employee in providing that? If they don't want to come in, can they say that legally and not come into work legally?
The employer has the obligation to provide a safe workplace to every employee and every contractor. So that's the starting point to answer that question. Now, but the big question mark, and this actually ties into your former question to me about is anybody exploiting or taking advantage of this? And because this is a unseen virus, some people apparently can transmit it and they don't even have display any symptoms. Do you know whether or not your workplace is safe? And that's still, for most people, an unknown question. So could the mere fear of potentially being able to contract a virus in the workplace be cause for me to say I'm simply staying home? Well, I think first of all, if you're a person who's with a compromised immune system, or you're particularly vulnerable, or you perhaps have people at home who would be particularly vulnerable, the employer is going to have to be more reasonable in respecting that request. That being said, even if you're not, there is some merit to saying, I know that this can spread. I've read the news. I've watched the briefings from the experts on television. I've listened to the radio. I've listened to podcasts like this. I'm worried. I think this is harming me. I want to stay home. In these circumstances, my view would be that would not be grounds for terminating the employee. On the flip side, though, it also doesn't mean that the employer would have to pay the employee. That being said, hopefully most employers will accommodate this and try and keep things as normal as possible, because we all have a mutual interest in keeping this economy running.
So there's some complications there that I just want to work through. So if an employee says, I don't feel safe to come into work, the employer, just pre-pandemic, whatever, always has the obligation to provide a safe workplace. So if there's an argument to be had from the employee that the workplace is not safe, then the employer has an obligation to has no legal standing to force them to come to work, but they don't actually have to pay them.
That's correct. I mean, let's face it. We wake up every morning, and each of us has a choice. We're going to go to work or we don't. And the overwhelming majority say, yes, I'm going to work. If you don't, eventually your employer is going to stop paying you. They're going to terminate you, or you've terminated the employment by not showing up. This is one of those times, though, where there's perhaps a good reason to wake up in the morning and say, I don't think I should go to work. This is scaring me. I think I might get sick. I don't think the workplace is safe, and I'd like to stay home. So, would I give an employer in those circumstances advice that they can terminate that employee? Absolutely not. It would not be a prudent move for any employer. Employees are the reason that business is run. You need them, so take care of them. The flip side, though, is that the employer generates presumably revenue from your work, and that's how they pay you. If that's not happening, the employer is going to run out of resources. Now, some employers might have a nest egg. They might be in a position to continue paying employees. I know several are at the moment, but how long can that last? And that can't go on indefinitely, of course.
Yeah. There's some further complications there that I just want to touch on. So you can legally terminate someone if they're not coming to work, even if it is for the reason of COVID. Like if somebody's not wanting to come to work, and because it's not safe for them, you can terminate them, but it's on the grounds that this is how we make money, you coming to work. There's some gray zone. Help me understand that a little further.
If I gave that impression, that's not what I meant to convey. I would say this unique circumstance probably gives the employee excuse to not come into work and make it a terminable offense. But at some point, there would be a break of the employment contract. If the employee doesn't come to work and says, well, I'm going to be gone for 6 months guaranteed, for example, because I don't think this virus is going to alleviate by then, that's probably overreach by the employee. But if it's for now saying, to be safe, I would not like to go to work, I don't believe that would be grounds for termination at this point in time.
Okay. Yeah, that clears that up. And small businesses have such a unique circumstance right now because a lot of their revenue generation is predicated on that person showing up to work. And so in the situations that I've seen, the employer is saying, look, I would love to keep you, but I can't. It's not because, essentially it's because I cannot provide a safe workplace, or there's a policy that our business is shut down until further notice. Are you seeing a difference between how small businesses are approaching this and big organizations? Because I bet there's a difference in complexity and a lot of gray zone in both areas.
In the short term, I think some of the larger organizations that have the resources have sent employees home en masse and are remaining to temporarily pay them. Smaller businesses appear to be less equipped to have the ability to continue to pay their employees. That if there is a difference there. Now, that's not to say that all small businesses are stopping to pay their employees. I know some that are doing it and are trying to. But whether your organization is large or small, it's ultimately going to come down to what are your resources. I mean, it's uncharted territory. Nobody knows what's going to result, but those are, in general, if those who have had the resources where they have to shut down or think it's important to shut down and can still pay their employees, I've generally seen they're making an effort to do so.
Interesting, and that's a good sign, because we hope this can resolve in the near term, and then everyone can get back to work. Ben, I'm wondering what you've seen in terms of, like, on the wellness side of things. With has there been an increase in mental health related complaints or discrimination, harassment on that front? Where are you seeing the shift, if any?
Absolutely, Ryan. As part of my practice, I always like to keep up to date on things like social psychology and neuropsychology, and I'm a bit of a geek in that area. So um, we might be kindred spirits in that sense. But what I am seeing is almost a scarce resources type of trigger for some of the fear around this. And when I talk about scarce resources, I think there was some social psychology studies that examined where people perceive there's a scarcity of a crucial resource like employment, money, food,
Toilet paper.
toilet paper. You read my mind. Uh, then people are sort of rushing toward that confluence, if you will, of this resource, and there's almost a perception that someone's trying to take this from them. And so when it comes to the employment context, I believe there presently are cases where the employers are dealing with triggers for these perceptions, like why them and why not me type of thinking with things like jobs. And so that can be a trigger for a lot of very negative human experiences. There's been some social psychology studies around the segregation in the United States, and there was this sort of scarce resources trigger for some of the thinking in that era that the social thinkers looked at. And so I'm really concerned when it comes to wellness and mental health within the employment context, because if employers don't handle this very carefully, we're going to see a rise in things like bullying and harassment, which under the 2018 amendments to the Occupational Health and Safety Code in Alberta have made that an employer obligation of providing a safe workspace. So harassment is a category of harm within the workplace and risk that employers have to manage carefully. Well, bullying is a subset of that harassment category. And so employees who are stressed, who maybe aren't sleeping as much, who are very concerned about the virus, and they have families at home that they need to look after, and they're coming to work perhaps under situations where they aren't at their best. I am concerned about the wellness component that we're dealing with here, both on behalf of the employer as well as on behalf of the employees, of making sure there's a safe work environment.
And you mentioned harassment and bullying and our legal obligations as employers. Where does mental health, where does psychological safety fit into that paradigm?
Well, I've read some authorities on this topic, and of course, in terms of being thought leaders in our space, I'm sure you've read these as well, Ryan. The employers in Alberta have an obligation to make sure that their workplace is safe. And so when it comes to safety, we now see starting to be included in that mental health concerns. And if they aren't supportive of wellness and mental health in Alberta, certainly I believe there's a huge risk to employers who perhaps they didn't do things in a very prudent way, and they've caused some mental health challenges, or they failed to support an employee who's feeling stressed or feeling undue anxiety in this situation. Maybe not undue, but certainly they're feeling some anxiety. And if that's not supported by the employer, there's a big risk right now. I think this is a positive change for our society, that we start to see the invisible illnesses as something that, although you can't objectively feel the same thing the employee is suffering, it's still a real illness that they need to help manage.
When you say risk, what do you mean risk for companies?
Yeah, that's a good question. I believe the honest answer is that the cases have not yet evolved to the point where I could give a concrete numerical value to that risk. But I can say that the liability is certainly there in terms of whether or not there's an obligation. I think it's now clear there's an obligation on behalf of employers to support mental health in Alberta. I have not yet seen any precedent, if you will. It's a legal term to say. I haven't read any judges' decisions that really put a number on that. And so people right now, I believe, should be extra cautious around that because we just don't know.
And from what I understand, there's similar legislation in Ontario, and other provinces have not quite. Like Alberta is one of the, I don't know what you call it, if it's a standard or one of the foremost in terms of putting it into law. So is my reading correct in saying that it is law that you need to create a psychologically safe workplace? Like that's the law, but the interpretations thereof could be a whole host of things.
Well, it's not yet, to my knowledge, Ryan, it's not yet specifically addressed in the legislation that it has to include mental wellness, like mental health wellness. What I'm saying is there is case law out there. So I started by saying there's common law. And so the judge-made law in Canada is quite clear that there is that obligation. But in terms of the legislated standard, it could be clearer in our code, and I think we're eventually going to go that direction. So the answer is no. I don't think there's specific categorization yet of just what types of things employers have to do. I think there's a general obligation for employers to support wellness and mental health.
Okay, that's really interesting, and it applies now more than ever because our, I believe our psychological health and safety is being put at risk by the chaos and the resource scarcity mentality. Do you foresee there being more cases or more complaints or more anything in this space from your perspective?
Yeah, and I can use an example on that one. I've been consulted by some employers who have put in policies that preceded actually the COVID-19 crisis, the global crisis. And this is a very rapidly moving, very rapidly evolving situation that we're looking at in society right now. But one employer had implemented what they believed was just a global policy for their staff. And we're talking about a multinational corporation. And so they imposed some policies around what you can and can't do at your workstations in the workplace. In terms of beverages that are allowed at a workstation, I guess they're working with technology. They don't want damage to the machines. But when COVID-19 comes around, things are almost recast in the eyes of the employee. And so I think employers have to really start to rethink some of these accommodations. If employees raise concerns, as long as they are not putting the employer at risk, financial risk or risk to their operations, employers should really think twice about how strongly they enforce things that maybe just don't matter currently, or maybe they don't matter as much as supporting the employees' comfort, their overall sense of well-being.
Yeah, I'm hearing from both of you that if there hasn't been already, there needs to be a shift to the softer side of the policy and the softer side of the law, which is around, communication and showing you care and trying to be reasonable and being open and authentic about like what is going on, and we're all in this together.
That's right.
Yeah, and it's funny hearing that from two lawyers.
Especially litigators.
yeah, absolutely. Yeah, and
just on that point, there's and it's called the duty to accommodate in part, and that has been very much a growing area of employment law in the last decade or so, for sure.
The thing I think small businesses, all businesses, and the HR leaders that we've been talking to, there's a fear that's driving behavior, and the advice I can give, which is very HR and psychological safety kind of advice, is that the fear is going to drive our behavior, but it should drive it toward being more open and honest about how we're feeling about things and how we're looking at things. And this is just a whole new world. And that there's not one group that has the answers right now. I think that lawyers are in a particularly good position to provide a great many of these answers, but it's become clear with this conversation that there's still a lot up in the air, and it's more helpful now than ever to reach out for help and ask questions to legal authorities.
Absolutely. And, if you find me that person who has all the answers, they're probably retired and they're probably living on a yacht somewhere and they don't have any concern whatsoever about COVID-19, but I don't know that person.
Yeah. And in a time like this, I find people are turning to law, medicine, and government. And maybe maybe it used to be the church or something you could throw in there, but Canada is becoming an increasingly secular country, and parts of the US are too. But in times of chaos, there's a couple of groups of practitioners that are looked upon to have the answers. And you're absolutely right. There's no one group that has all the answers on this thing, and we're all trying to figure it out together.
You got it.
If people want to get a hold of you, how do they do that? What's the best way to get your advice around a question? What's the best way to contact you individually in your firm if they have questions around employment and legalities and the rest?
Well, they can go to www.walshlaw.ca, WALSHLAW.ca. Up on our website, we have a very comprehensive listing of our practitioners and our practice groups. And all of the contact details are available on that website or by telephone, 403-267-8400. We are available by video conference. We are supportive of having meetings by telephone and by technology. We could still prepare letters. We can still talk with counsel. We're here to support you. And technology is making that easier and easier, as you can see by our conversation today. So thanks for your questions, Ryan, and appreciate the questions.
Yeah, and thank both of you for your guidance in all this. There's likely to be a time in the not so distant future where I reach out again and to see if we can get on another conversation. I'd be interested to know if in like a month or two, if things are more clear and if there's more precedent or more case law or something around this that provides further guidance. But this conversation was very helpful, and I think our listeners will find it helpful. So thank you both for joining me today.
Thank you.
Thank you for having us.
And thank you, listeners, for joining me. My name is Ryan Todd, and this is Beyond the Checkbox, where you learn how to integrate more mental wellness into your organizations, learning from frontline leaders. Today we had Kent Jesse and Ben Kormos, two leaders in health law and litigation around employment agreements, and have helped become, what was the word you used, Ben? Guideposts, hiker, guide?
Guides.
They were hiking guides. They are hiking guides to all that is going on in the employment world today that is facing a lot of tumultuous and difficult times given the COVID response. So thank you for joining us today, and looking forward to our next episode.